The first and most important step is actually to sit down and write a new will, because any previous wills are now not valid. Unless you sit down and write a new will, then your wishes and your intentions will not be reflected anyway. Marriage is obviously a very important change in one's life. So now you should consider what you leave to your current partner. You should also consider the future, whether you're going to have any children, how you're going to look after your children, what's going to be left to your children. Say you've had a previous marriage and you've got children from a previous relationship, and you've previously prepared a will which provides for those children. Now, because you're married, that will is no longer valid. And so therefore, how can you guarantee that your children from previous marriage will be looked after?
How does marriage affect an existing will? Does the will become automatically invalid? Are there any exceptions to this?
People often don't realize that as soon as you get married, your existing will is invalid and is revoked. And so the only exception to that is if you made your existing will recently and it was made in contemplation of you being married. And most often people, when they make a will, they don't think that far in advance, or they haven't done so. So then that leaves a real danger that you no longer have a will, you are deemed as dying intestate, and then the rules of intestacy will apply, which means that any gifts that you may have made to certain family members, certain charities, will no longer apply. So the first and most important step is actually to sit down and write a new will, because any previous wills are now not valid. Unless you sit down and write a new will, then your wishes and your intentions will not be reflected anyway. Marriage is obviously a very important change in one's life. So now you should consider what you leave to your current partner. You should also consider the future, whether you're going to have any children, how you're going to look after your children, what's going to be left to your children. Say you've had a previous marriage and you've got children from a previous relationship, and you've previously prepared a will which provides for those children. Now, because you're married, that will is no longer valid. And so therefore, how can you guarantee that your children from previous marriage will be looked after? And the only way to do so is to really sit down and go for a new will. Because the alternative is, by not having a new will, is to rely on the Succession Act. And the Succession Act will make provisions that in a circumstance, family circumstance, where you have an existing spouse and you have children from a previous marriage, the current spouse will be entitled to all of your personal effects. Then they will be entitled to what they call a statutory legacy amount, which is around $490,000. And then they will be entitled to 50% of what's left over. And so that means then the remaining 50% will be distributed equally between any children from the previous marriage. And this may or may not be a fair allocation.
Let's talk about separation and divorce. How does that affect your will?
So a divorce will importantly revoke certain aspects of your previous will, because naturally you're now divorced from that partner, right? So if that partner was the executor, then they should no longer be the executor. If that partner was a beneficiary, they should not be entitled to any gifts, because obviously you've gone through a divorce. You may have had the matter in the family court where there has been provision for assets and parental responsibilities, right? So what people don't realize is what happens between a period that you're separated when you're legally divorced. And often that period can be anywhere from 12 months and more, right? And so in that period, even though you're separated but not divorced, so what it means is that there is actually no change to your previous will, assets, and you've left your previous partner as the executor, then they will be entitled to be your executor, and they will still be entitled to those assets, which may not be your intentions, right? Particularly as you're going through separation and ultimately divorce. And so it's important, really important, that during that period before you actually get divorced, that you rewrite your will.
How can someone ensure that their will reflects their current marital status and intentions?
So the most important thing is to use this opportunity to reconsider your existing estate planning and to sit down and update your will. It's also very important to understand that marriage does not automatically revoke the appointment of your previous partner as a power of attorney. And so you actually have to now amend that document and revoke it in writing. Whereas conversely, in relation to an enduring guardian, marriage will revoke the appointment of your previous partner as an enduring guardian. These life events are important for you now to really reconsider your estate planning and make the necessary changes. A lawyer will help you think about things holistically. So they won't just focus on one thing. So all of a sudden, this life events change. All right, and so we have to help you think about how does this affect your will? How does this affect your power of attorney? How does this affect your enduring guardian? Helps you really plan and look at things holistic. It's so important because your will is your voice after you're gone. And if you want to ensure that your legacy is left the way it is, you have to update it as things change. And if you don't, then the danger is that you're going to create disharmony, that there will be people who are not happy with the situation, and there may be challenges to your will.